Veuillez vous asseoir. L'audience est ouverte. La Cour se réunit aujourd'hui pour entendre le premier tour de plaidoirie de la Somalie. Je donne à présent la parole à Son Excellence M. Mona Al-Sharmani, agent adjoint. Madame, pardon. À Son Excellence Madame Mona Al-Sharmani, agent adjoint. Excellence, vous avez la parole.
Mr. President, distinguished members of the court, it is a great honor and a privilege for me to appear before you today as Deputy Agent for the Federal Republic of Somalia. With me on behalf of the Somali government is our co-agent, His Excellency Ali Saeed Faqi, Somalia's ambassador to the Kingdom of Belgium, and the Honorable Ahmed Dahir, Attorney General of Federal Republic of Somalia. Please allow me to begin with an expression of thanks. The President of Somalia, His Excellency Hassan Sheikh Mahmoud, has personally asked me to convey to you, to the entire court, the gratitude of the Somali nation. This is the first time Somalia has appeared as a party before an international court or tribunal. Even at this early stage, we have been greatly comforted by the efficiency and impartiality with which you have managed our case. We are confident that this court will, as its name attests, do justice in accordance with international law. We also wish to thank the Honorable Agent of Kenya for the kind greetings he extended to us yesterday and returned to him and his team warmly. Mr. President, distinguished members of the court, it is no secret that Somalia has faced considerable challenges. Our recent history has been fraught with instability, poverty, and conflict. For long years, we have endured civil war, humanitarian disasters, and the scourge of terrorism. But a brighter future is within our grasp. Since 2012, Somalia has had a functioning federal government under the leadership of President Hassan Sheikh Mahmoud. With the support of international partners, we have a constitution that enshrines the rule of law and parliamentary democracy as bedrock principles. Public institutions are being rebuilt. Next month, we will have presidential and parliamentary elections. And life is springing back to cities like Mogadishu, Hargeisa, Bosaso, Kismayo, Galkayo, Baydawa, and many other places in Somalia. Local businesses are doing well. A new generation of Somalis is graduating with educational training, and many in the Somali diaspora are returning to assist the rebuilding efforts. We recognize and express our deep gratitude to our Kenyan brothers and sisters for their enormous assistance in making this possible. In fact, we wish to thank all our African and other partners who continue to stand shoulder to shoulder with us in taking our country forward. Mr. President, members of the court, for the first time, Somalia is in a position to have recourse to international dispute settlement mechanisms to protect our rights under international law, including our rights over marine areas and the resources they hold. As one of the world's poorest countries, those resources are critical natural assets vital to the future prosperity and stability of our nation. They will play a key role in assuring Somalia's continued development in a way that benefits our people. Yet, our ability to explore for, let alone exploit, those natural resources has been seriously hindered by the lack of a defined maritime boundary with Kenya. In the absence of an established boundary, Somalia has exercised restraint and refrained from activities in the disputed area. Regrettably, Kenya has not taken the same approach. It seems to consider that the area in dispute belongs to it. Yesterday, you heard the Honorable Agent for Kenya claim that Kenya has exercised uncontested jurisdiction in this maritime area since 1979. Somalia does not agree, but the statement does reflect Kenya's misguided attitude. Kenya has moreover granted concessions in the area, and exploration activities are already taking place. Kenya's approach is of great concern to Somalia. The resolution of this case in a matter that achieves an equitable solution in accordance with the rule of law will allow us and others to know what is rightfully ours and realize our full potential. It is for that reason that the issues that are at the heart of this case unite all Somalis. Whatever other differences may divide us, it is no exaggeration to say that the eyes of the entire Somali nation are upon us today, and they will remain upon us until this court renders its ultimate decision. Mr. President, distinguished members of the court, I know the issue that brings us today concerns Kenya's objection to the court's jurisdiction, not the merits of the case. But speaking on behalf of the government of Somalia, we think it is important for you to understand something of our motivation for coming before you and how the Somali nation has entrusted its aspirations to you. Yesterday, you heard Ambassador Muchiri suggest that Somalia rushed to the court without giving negotiations a chance to succeed. The Honorable Ambassador hinted that the institution of these proceedings was an act of bad faith. She even accused us of deception. With great respect to our neighbors, Somalia takes great exception to that unfortunate and erroneous characterization. Appeal to international justice should never be considered an act of bad faith. On the contrary, the institution of proceedings in this great court is an act of faith. Faith in Somalia's capacity to defend its sovereignty and sovereign rights, faith in international justice, and faith in this court's wisdom. That is why we are here today. We seek nothing more and nothing less than to have our maritime boundary dispute with our Kenyan brothers and sisters be resolved finally and definitively in an equitable manner, in accordance with the requirements of international law, including the law of the Sea Convention. Doing so will serve the interests of peace and stability in the region, and it will confirm the central role of this court in resolving disputes of this kind. Somalia has not rushed to the court prematurely. As the evidence Somalia has placed before you demonstrates, we negotiated in good faith and with great effort and energy before initiating those proceedings, but to no avail. I personally had the honor of participating in those negotiations over 2 intense rounds. They were not just technical level meetings, as you heard yesterday. Indeed, our respective foreign ministers personally presided at the second round. The talks were hard and sometimes heated. The position taken by the parties were far apart and irreconcilable. Kenya insisted that the boundary must follow a parallel of latitude. Somalia insisted that the jurisprudence of the court and other international tribunals required a delimitation based on equidistance. We could not even agree on a method of delimitation, let alone a boundary. Views were exchanged, no movement occurred. Kenya then failed to honor its commitment to attend a subsequent meeting, a meeting that it insisted on having as a last and final resort, and did so without prior notice or later explanation. We only learned of its purported security concerns when it filed its preliminary objections in October 2015. Counsel for Kenya asked yesterday why we submitted our application so promptly after Kenya failed to attend those meetings. The answer is very simple. As you will hear, our counsel will explain shortly, this third meeting was specifically intended to be a final opportunity, a last try to bridge our differences. There had been no movement during the prior sessions, and Kenya's unilateral activities in the disputed area were ongoing. Adding to the sense of urgency was the knowledge that Kenya could, by its terms, withdraw its Article 36(2) declaration at any time and forever prevent us from accessing this great court. Under the circumstances, Somalia did what any prudent state would do. We considered our options and prepared for all contingencies. When Kenya failed to turn up for the third and final round of talks without explanation, we felt we had no alternative but to come before this court to protect our rights under international law. Mr. President, members of the court, Kenya's objection to your jurisdiction is, as you heard yesterday, founded primarily on the argument that the 2009 MOU constitutes an agreement to have recourse to some other method of dispute settlement within the meaning of Kenya's reservation to its Article 36(2) declaration. Somalia disagrees. In our view, the one and the only purpose of the MOU was to assure that there would be no obstacle to the CLCS consideration of our two countries' submissions concerning the establishment of the continental shelf beyond 200 nautical miles. The very title of this document confirms this. The MOU is entitled Memorandum of Understanding between the Government of the Republic of Kenya and the Transitional Federal Government of the Somali Republic to grant each other no objection in respect of submissions on the outer limits of the continental shelf beyond 200 nautical miles to the Commission on the Limits of the Continental Shelf. There is no indication that the MOU was intended or indeed, in fact, establish an agreed method of dispute settlement that could bar this court's jurisdiction. As our very able counsel will show in the course of this morning, at no time, whether before or after the signing of the MOU, did Somalia or Kenya understand the MOU to have the effect Kenya now seeks to ascribe to it. As I said, we did negotiate and negotiate hard. The record shows that we engaged in a substantive and detailed exchange of views. Kenya never once expressed the view that negotiations were provisional only, and that any agreement, should there be one, would have to wait until after the CLCS has issued its recommendations. That would have been illogical and contrary to Kenya's express wish to reach an amicable solution promptly. Mr. President, members of the court, in Somalia's view, Kenya cannot truly believe that the MOU created a binding commitment to an alternative method of dispute settlement. Rather, it appears that Kenya is looking for a way to avoid the court's exercise of jurisdiction and thus avoid a binding judgment upon the parties. It is hard to avoid the conclusion that Kenya lacks confidence in the merits of its case. The court has never delimited a boundary on the basis of Kenya's approach, and the applicable international law, the 1982 Convention, does not direct it. Nor do the decisions of other international courts or arbitrary tribunals offer support to Kenya's unlikely arguments. Perhaps that's why Kenya has now fallen back to an even more unlikely argument, that UNCLOS itself constitutes an agreement to an alternative method of dispute settlement within the meaning of its reservation to its Article 36(2) declaration. This argument, which took up all of one sentence in Kenya's written pleading, has now assumed a much greater prominence. As Professor Sands will show, it can be rejected just as easily. Kenya is represented by able and experienced counsel. It knows that it does not have a serious case on the merit, but if they can force us back into negotiations without hope of judicial recourse, they can refuse to agree unless we give them a large portion of our EEZ and continental shelf something no self-respecting Somali government could ever do. Kenya can use its greater political and economic power to prevent us from accessing the resources to which international law entitles us. Moreover, continued uncertainty over the course of our maritime boundary does not benefit anyone. The dispute will remain an unwelcome source of tension between our two countries at a time when what is needed is more increased cooperation. If we are to have any hope of a durable and equitable solution that contributes to regional peace and security, it lies here in this great hall of justice and in the hands of the distinguished members of this court. Mr. President, members of the court, with that I come to the organization of our first round presentations. Following me to the podium this morning will be Professor Alain Pillay. He will explain why, as a simple matter of treaty interpretation, the MOU does not constitute an agreement to settle the parties' delimitation dispute by the exclusive means of negotiation only after the CLCS issues its recommendation. Professor Pillay will be followed by Mr. Paul Reichler, who will address the evidence relevant to Kenya's preliminary objection. Mr. Reichler will address circumstances of the MOU's conclusion and show that no one at any time took the view that the MOU created or was intended to create a dispute settlement mechanism. This includes Norway, which was instrumental in the drafting and signing of that document. Mr. Reichler will show that the only purpose of the document was to enable the CLCS to consider both Somalia's and Kenya's submission in respect of the continental shelf beyond 200 nautical miles. Mr. Reichler will also show that the conduct of the parties following the execution of the MOU constitutes further compelling evidence that neither Kenya nor Somalia considered the MOU to have established a specific or exclusive means of settling the maritime boundary dispute, let alone one that obligated the parties to resolve the dispute only by agreement and only after the CLCS had issued recommendations on their respective submissions. Finally, Professor Philippe Sands will demonstrate that the MOU does not fall within the scope of Kenya's reservation to its optional clause declaration. He will also show that even if the MOU had created an obligation to engage in negotiations, which Somalia emphatically rejects, any such obligation has been amply fulfilled. He will also show that Kenya's newly developed argument based on UNCLOS is ill-conceived. On any view, then, there is no bar to this court's jurisdiction. Mr. President, members of the court, thank you for your time and courteous attention. I ask that you now invite Professor Pillay to the podium.
Je vous remercie, Madame. La parole est à Monsieur le professeur Alain Pillay.
Merci, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs de la Cour, tout à l'heure, le professeur Sands montrera que le Memorandum of Understanding, le MOU, n'entre pas dans les prévisions de la réserve du Kenya à la compétence de la Cour. Cela suppose de préciser sa signification. Telle est la tâche que Maître Reichler et moi nous partageons en suivant la voie tracée par les articles 31 et 32 de la Convention de Vienne sur le droit des traités. Il m'échait d'établir que l'interprétation du MOU avancée par le Kenya conduit à un résultat manifestement absurde et déraisonnable lorsqu'on en interprète le texte de bonne foi, dans son contexte et à la lumière de son objet et de son but. Ensuite, il maestro montrera que dans la pratique ultérieurement suivie par les parties, aussi bien que dans les travaux préparatoires et les circonstances dans lesquelles le mémorandum a été conclu, confirment entièrement l'interprétation que nous en faisons. Et je vous prie, Monsieur le Président, comme je prie les mannes de bas de vent, de bien vouloir me pardonner, ce mémorandum, je le désignerai par son sigle anglais, MOU, car mémorandum de compréhension ne signifie strictement rien en français, et ni MOU ni MOU ne sonnent particulièrement bien dans la langue de Racine et de Baudelaire. Toute l'argumentation du Kenya contestant votre compétence pour vous prononcer sur la requête de la Somalie repose sur le dernier paragraphe du MOU, ou plus exactement sur un membre de phrase de ce paragraphe qui l'isole de son contexte. I quote, "The delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles," and this is the phrase, "shall be agreed between the two coastal states on the basis of international law after the Commission has concluded its examination of the separate submissions made by each of the two coastal states." End of quote. Kenya contends that this paragraph, and I quote it, sets forth the method of dispute settlement that would follow the CLCS review and specifies that it shall apply to the entire maritime boundary, both within and beyond 200 nautical miles. End of quote. Négligeant la règle générale d'interprétation, cette interprétation originale ne tient compte ni du contexte de la disposition sur laquelle le Kenya fait fond, ni de l'objet et du but du MOU, ce qui conduit à un résultat qui est manifestement absurde et déraisonnable. Monsieur le Président, dans sa présentation d'hier matin, Mathias Forteau a résumé en moins de 2 minutes les 5 premiers paragraphes du MOU pour se concentrer exclusivement sur ce paragraphe 6. Quant au professeur Akavan, il a embrayé immédiatement sur celui-ci, sans s'embarrasser le moins du monde des paragraphes précédents. Ce faisant, ils ne tiennent aucun compte de la règle générale d'interprétation énoncée à l'article 31 de la Convention de Vienne de 1969, dont j'ose à peine rappeler qu'il exprime le droit international coutumier. Je précise au passage, Monsieur le Président, que je me fonde sur cette disposition sans pour autant concéder, ni d'ailleurs nier, que le MOU soit un traité en vigueur entre les parties. Il n'est pas nécessaire de prendre position sur ce point, il suffit d'interpréter cet instrument pour constater qu'il ne constitue nullement un obstacle à l'exercice de votre compétence. Et il est reconnu et indiscutable que la règle de l'article 31 de la Convention de Vienne s'applique aussi, par analogie, à des instruments non conventionnels. En vertu du premier paragraphe de cette disposition, un traité doit être interprété de bonne foi suivant le sens ordinaire attribué aux termes du traité dans leur contexte et à la lumière de son objet et de son but. Conformément à l'article 31 de la Convention de Vienne, le sens ordinaire des termes d'un traité ne peut être défini que dans leur contexte et à la lumière de l'objet et du but du traité. Et c'est cela, Monsieur le Président, la règle générale d'interprétation. C'est une norme globale et complexe dont on ne peut détacher les éléments un par un comme on effeuille la marguerite. Une règle tellement bien établie que la Cour n'a pas besoin de s'y attarder longuement, elle l'applique dans sa globalité sans ressentir le besoin de s'en expliquer. Dans son rapport final sur le droit des traités de 1966, la Commission du droit international avait expliqué, je la cite, qu'en mettant le titre de l'article « Règle générale d'interprétation » au singulier, la Commission avait voulu indiquer que l'application des moyens d'interprétation prévus dans l'article constituait une seule opération complexe. tous les différents éléments tels qu'ils s'y trouvent présents dans une situation donnée seraient jetés dans le creuset et la résultante de leur interaction constituerait l'interprétation juridiquement pertinente. Ainsi, l'article 27, qui allait devenir l'article 31, est intitulé « La règle générale d'interprétation au singulier » et non « Regles generales » au pluriel, parce que la Commission a voulu souligner que le processus d'interprétation constitue un tout et que les dispositions de l'article forment une seule règle étroitement intégrée. Fin de citation. Cette caractéristique essentielle de l'article 31 et ses conséquences pratiques ont été excellemment rappelées dans la sentence arbitrale du 12 mars 2004 rendue dans l'affaire de l'apurement des comptes entre la France et les Pays-Bas, qui a insisté vigoureusement sur l'unité de la règle générale d'interprétation posée à l'article 31. Telle est aussi la jurisprudence constante de la Cour, qui a toujours pris grand soin de ne pas détacher les uns des autres les 4 éléments clés énumérés à l'article 31, texte, objet et but, contexte et pratique ultérieure. Comme le disait déjà la Cour permanente en 1922, lorsque l'on procède à l'interprétation d'un traité, je cite, « il faut évidemment lire celui-ci dans son ensemble et l'on ne saurait déterminer sa signification sur la base de quelques phrases détachées de leur milieu et qui, séparées de leur contexte, peuvent être interprétées de plusieurs manières. C'est dire aussi que l'interprétation, selon la règle coutumière codifiée à l'article 31 de la Convention de Vienne, est en dernière analyse un exercice global qui ne devrait pas être mécaniquement scindé en parties rigides. » Fin de citation. Or, c'est très exactement ainsi que procède le Kenya. Au lieu de s'interroger sur le sens de la disposition à interpréter, il le postule pour décréter ensuite qu'il n'y a rien à interpréter. C'est procéder à l'envers. Il faut d'abord interpréter à la lumière de la règle générale de l'article 31, et ce n'est qu'ensuite que l'on peut déterminer si le texte est clair ou non. Lorsque l'on se livre de bonne foi à cette opération, on constate que le MOU est en effet dénué de toute ambiguïté, mais qu'il signifie le contraire de ce que nos amis voudraient lui faire dire. S'il y avait une ambiguïté, il faudrait alors recourir aux moyens complémentaires de l'article 32. Ici, on peut y recourir, mais non pour dissiper une ambiguïté, il n'y en a pas, pour confirmer l'interprétation qui résulte de l'application de la règle générale, globale, complexe de l'article 31. L'interprétation qu'avance le Kenya s'en émancipe totalement. Elle ne tient compte ni de l'objet et du but du MOU, ni de son contexte. Ancelotti, Monsieur le Président, n'avait pas toujours raison. Mais on ne peut que partager, au sujet de l'évidentialisme kényan, la perplexité qu'exprimait le grand juge italien au sujet de l'interprétation de la Convention de 1919 concernant le travail de nuit des femmes, lorsqu'il se demandait, je le cite, « comment il est possible de dire qu'un article d'une convention est clair avant d'avoir déterminé l'objet ou le but de la Convention. Car c'est seulement dans cette Convention et par rapport à cette Convention que l'article assume sa véritable signification. La première question qui se pose est donc celle de savoir quels sont l'objet et le but de la Convention dans laquelle se trouve placé l'article à interpréter. » Fin de citation. Et vous-même, mesdames et messieurs les juges, avez souvent et abondamment insisté sur la nécessité de tenir compte, dans toute interprétation, du but et de l'objet de l'instrument en cause. Comme l'a relevé assez récemment la CDI, je le cite, « Je la cite, « Il n'est pas facile de synthétiser en une formule unique l'ensemble des éléments qui doivent être pris en considération pour déterminer dans chaque cas concret l'objet et le but du traité. Cette opération relève sans aucun doute davantage de l'esprit de finesse que de l'esprit de géométrie. Esprit de finesse dont j'ai le regret de constater que nos amis et contradicteurs manquent fâcheusement lorsqu'il s'agit du MOU dont ils s'obstinent à vouloir interpréter géométriquement une phrase isolée de son contexte. Dans cette même étude récente, la CDI a tenté la synthèse suivante. L'objet, je la cite, « L'objet et le but du traité doivent être déterminés de bonne foi en tenant compte de ces termes dans leur contexte, en particulier du titre et du préambule du traité. On peut également avoir recours aux travaux préparatoires du traité et aux circonstances de sa conclusion et, le cas échéant, à la pratique subséquente des parties. » Fin de citation. Ici encore, précise la Commission, il ne s'agit pas de décortiquer le traité, d'examiner ses dispositions l'une après l'autre, mais bien d'en dégager l'essence, le projet global. Fin de citation. Ceci suppose que l'on se réfère non à quelques mots ou membres de phrases isolées, mais, comme la Cour l'a fait à plusieurs reprises, à la structure même de l'instrument interprété telle qu'elle ressort de ces dispositions prises dans leur ensemble. Non sans bon sens, la Cour a rappelé que l'objet du traité est celui qui est indiqué dans son titre. Quel est-il en l'espèce? Memorandum of Understanding between the government of the Republic of Kenya and the Transitional Federal Government of the Republic of the Somali Republic, to grant to each other no objection in respect of submissions on the outer limits of the continental shelf beyond 200 nautical miles, to the Commission on the limits of the continental shelf. Je répète, afin d'accorder à chacun non-objection à l'égard des communications à la CLPC sur les limites extérieures du plateau continental au-delà de 200 000 marins. Tel est, mesdames et messieurs les juges, l'objet du MOU. Il n'est pas d'échapper à la compétence de votre Cour, comme le voudrait le Kenya, qui affirmait dans ses exceptions que, je cite, « The object and purpose of the 2009 MOU was to agree on a method for the final settlement of the maritime boundary between Kenya and Somalia, both within and beyond 200 nautical miles. » Comme l'indique clairement son titre, le but du MOU est de permettre à la CLPC de s'acquitter de sa fonction de délinéation du plateau continental des deux États, nonobstant leurs différends en ce qui concerne sa délimitation latérale, chacun s'engageant à ne pas objecter aux communications de l'autre. Et je comprends dans ces conditions que nos amis de l'autre côté de la barre aient préféré faire profil bas sur ce point. Tout juste le professeur Forteau a-t-il fait une allusion furtive au titre du mémorandum pour ensuite procéder à l'envers. Quel que soit l'objet et le but du traité ou son intitulé, dit-il, il n'en demeure pas moins que l'accord de 2009 contient, il souligne, une disposition consacrée à la délimitation. Assurément, Monsieur le Président. Mais que signifie-t-elle, cette disposition? C'est notre problème, et il ne peut être résolu que si les termes de cette disposition sont interprétés dans leur contexte et à la lumière de l'objet et du but du traité. Et je remarque en passant que ce long titre, délibérément explicite, n'a pas été donné au mémorandum ex post au moment de son enregistrement par le Kenya, mais a fait l'objet de discussions entre les représentants des 3 États impliqués dans son adoption. Proposé à l'origine par l'ambassadeur norvégien Longva au chef du service juridique du ministère kényan des Affaires étrangères, M. Kiwaga, ce titre a été modifié à la demande expresse de la Somalie qui a souhaité que soit ajoutée la mention « to each other », à chacun. Compte tenu de la nature indécise du MOU, il est difficile de parler d'un préambule stricto sensu, mais il est patent que les signataires ont été incités à préciser leur principal souci dans un paragraphe, le 3e, qui est tout à fait éclairant et qui contribue très utilement à clarifier le sens à attribuer à ces termes. Je relève au passage que le Kenya décompte différemment les paragraphes. Ce décalage n'a pas d'incidence sur le raisonnement. Ce paragraphe 3 est projeté à l'écran. Permettez-moi, Monsieur le Président, d'en faire une lecture commentée. Les 2 États côtiers sont conscients que l'établissement des limites extérieures du plateau continental au-delà de 200 000 marins est sans préjudice, je souligne, sans préjudice, de la question de la délimitation du plateau continental entre des États ayant des littoraux adjacents ou qui se font face. La précaution est utile, car bien que la formule soit reprise tant par l'article 76, paragraphe 10 de la Convention des Nations Unies sur le droit de la mer, que par l'article 9 de son annexe 2, l'article 5A de l'annexe 1 des règles de procédure de la CLPC dispose, je le cite, que dans le cas où il existe un différend terrestre ou maritime, la Commission n'examine pas la demande présentée par un État parti à ce différend et ne se prononce pas sur cette demande en l'absence d'accord préalable de tous les États partis à ce différend. Je reprends la lecture du MOU. Bien que les 2 États côtiers aient des intérêts divergents en ce qui concerne la délimitation du plateau continental dans la zone en litige, ils ont un sérieux intérêt commun à établir les limites extérieures du plateau continental au-delà de 200 000 marins, sans préjudice, et je souligne à nouveau, without prejudice, de la future délimitation du plateau continental entre les 2 États. Nous y voilà, tel est l'objet même du MOU, s'assurer que la délimitation, l'établissement des limites extérieures du plateau continental des 2 États, ne soit pas retardée par l'absence de règlement du différend sur la délimitation. Je note d'ailleurs que les 2 États sont au moins d'accord sur ce point. Le Kenya écrit dans ses exceptions préliminaires, je cite, « It was apparent that an objection by either party would waste the considerable costs of gathering and analyzing data for the submission and create a situation of perpetual limbo. » End of quote. Et le MOU enfonce le clou. Sur cette base, les 2 États côtiers sont déterminés à travailler ensemble à la sauvegarde et à la promotion de leur intérêt commun en ce qui concerne l'établissement des limites extérieures du plateau continental au-delà de 200 000 marins. Au-delà de 200 000 marins. L'élément clé de cette disposition est que les 2 problèmes de délimitation du plateau continental dans la zone en litige d'une part, de délinéation vers le large du plateau continental auquel chacun des 2 États a droit d'autre part, que ces 2 problèmes, disais-je, sont découplés et que, sauf en ce qui concerne le point d'aboutissement de la frontière maritime, la solution de l'un n'est pas conditionnée par celle de l'autre. Et le Kenya en convient, je le cite, The second operative paragraph emphasizes that the MOU is without prejudice to the final delimitation of the maritime boundary. End of quote. Chasser l'interprétation naturelle, elle revient au galop. Ce paragraphe 3 est de nature à éclairer l'interprétation des autres dispositions du traité. Le paragraphe suivant commence par des développements largement explicatifs par opposition à normatifs. Il y est indiqué que le gouvernement somalien entend soumettre des informations préliminaires sur la limite extérieure de son plateau continental au-delà de 200 000 marins avant la date butoir du 13 mai 2009, y compris sur la zone en litige. Ainsi, se trouve réaffirmé par la Somalie le but du MOU, étant entendu que cette communication, je cite, n'influera pas sur les positions des deux États côtiers en ce qui concerne le différend qui les oppose et sera sans préjudice de la future délimitation des frontières maritimes dans la zone en litige, y compris la délimitation du plateau continental au-delà de 200 000 marins. Deux remarques textuelles sur cette sorte d'exposé des motifs de ce qui suit, Monsieur le Président. Premièrement, sur l'expression « y compris », « including », le professeur Akavan en déduit que la portée du MOU n'est clairement pas limitée au plateau continental étendu comme le prétend la Somalie. Assurément, cela veut dire en effet que les deux États ne pourront déterminer le point d'aboutissement de leurs frontières communes, y compris au-delà de 200 000 marins, qu'une fois reçues les recommandations de la CLPC. Deuxièmement, nos contradicteurs font grand cas du pluriel dans les expressions frontières maritimes et zones en litige. Je ne suis pas sûr que ceci ait une très grande importance. C'est une façon de parler fort habituelle et l'on utilise couramment en la matière de façon interchangeable le pluriel et le singulier. D'ailleurs, s'agissant de l'expression « zones en litige », elle n'est utilisée au pluriel que deux fois dans tout le MOU. Elle est au singulier dans le paragraphe 2 qui la décrit comme étant une zone de chevauchement du plateau continental. Même chose dans le paragraphe suivant et au début du paragraphe 4, celui actuellement projeté. Et puis le singulier se meut au pluriel à la fin de ce même paragraphe. Et on revient au singulier dans tout le paragraphe suivant, avant de repasser au pluriel dans le texte anglais du paragraphe 6, le seul qui fait foi, il est vrai, mais les traducteurs français, peut-être plus cartésiens, s'en sont tenus, eux, au singulier. Que déduire de tout ceci, Monsieur le Président ? D'abord, sûrement que ce mémorandum, rédigé en toute hâte, l'a sans doute été moins précisément et méticuleusement que nos contradicteurs voulaient le faire croire. Ensuite, que n'en déplaise à Mathias Forteau, on ne peut pas déduire grand-chose du double pluriel dont il fait si grand cas. Et je reprends ma lecture. On arrive à la fin du paragraphe 4, à l'énoncé de l'une des clauses de fond, qui elle, n'intéresse que la Somalie. Sur la base de cet accord, la République du Kenya ne voit aucune objection à faire figurer les zones en litige dans la communication par la République somalienne des informations préliminaires indiquant les limites extérieures du plateau continental au-delà de 200 000 marins. Le paragraphe suivant est synalagmatique et constitue le cœur du MOU. Il y est convenu que, je cite, « à un moment approprié, chacun d'eux soumettra séparément une communication à la CLPC, que cette communication, qui pourra comprendre la zone en litige, demandera à la Commission de formuler des recommandations à l'égard des limites extérieures du plateau continental au-delà de 200 000 marins, sans tenir compte des frontières maritimes qui les séparent, sans tenir compte de without regard to. Décidément, les deux exercices sont distincts. Ensuite vient la phrase clé à laquelle renvoie le titre du MOU. Les deux États côtiers donnent par la présente leur consentement préalable à l'examen par la Commission de ces communications portant sur la zone en litige. Les communications formulées devant la Commission et les recommandations approuvées par cette dernière à cet égard n'influenceront pas la position adoptée par les deux États côtiers concernant le différend maritime qui les oppose et seront sans préjudice de la future délimitation des frontières maritimes dans la zone en litige, y compris la délimitation du plateau continental au-delà de 200 000 marins, sans préjudice de la future délimitation des frontières maritimes dans la zone en litige, y compris la délimitation du plateau continental au-delà de 200 000 marins. Toujours la même chose, deux opérations distinctes, non conditionnées l'une par l'autre. La délinéation par la CLPC peut se faire sans préjudice de la délimitation latérale et vice-versa. Et c'est alors, mais alors seulement, que l'on en arrive au paragraphe 6, le seul que le Kenya daigne lire, la disposition pour laquelle il a les yeux de chimène. Il faut la lire, bien sûr, mais dans son contexte et à la lumière de son objet et de son but. La délimitation des frontières maritimes dans la zone en litige, y compris la délimitation du plateau continental au-delà de 200 000 marins, fera l'objet d'un accord entre les deux États côtiers sur la base du droit international après que la Commission aura achevé l'examen des communications séparées effectuées par chacun des deux États côtiers et formulé ses recommandations aux deux États côtiers concernant l'établissement des limites extérieures du plateau continental au-delà de 200 000 marins. Fin de citation. Et voici maintenant la traduction qu'en donne le Kenya au paragraphe 47 de ses exceptions préliminaires. Je cite: The parties agreed that following CLCS review, after which the outer limits of the continental shelf could be definitely established, the method of settlement for delimitation of the full extent of the maritime boundary will be a negotiated agreement rather than recourse to any compulsory procedures. End of quote. Interprétation trahison. Bien entendu, le paragraphe 6 ne dit nullement ceci. Il dit ce qu'il dit, à savoir que la délimitation complète des frontières maritimes entre les deux États se fera par accord après que la CLPC aura formulé ses recommandations. Ah, je sais, Monsieur le Président, j'ai ajouté un mot, l'adjectif complète, après délibération. Et horesco référence, il n'est pas dans le texte. Il n'y est pas, mais il y est nécessairement impliqué. L'y insérer n'ajoute rien à la signification inévitable du texte, mais il en facilite la compréhension, compte tenu du contexte de cette disposition et de l'objet et du but du MOU dans son ensemble. Et d'ailleurs, ce n'est pas moi qui l'ajoute, c'est le Kenya lui-même. Un accord devrait permettre d'arrêter la délimitation complète de la délimitation maritime. The method of settlement for delimitation of the full extent of the maritime boundary. Et hier, à plusieurs reprises, le Kenya a reconnu que c'est bien de finalisation qu'il s'agit, vous trouverez les références en note. Le MOU n'empêche nullement les parties de négocier un accord, et cela implique qu'elles peuvent le conclure. En revanche, celui-ci ne peut être finalisé, finalized, completed, par la fixation de son point terminal qu'une fois acquises les recommandations de la Commission. Et cela est fort sensé, Monsieur le Président. Il relève en effet de l'évidence que le dernier segment de la frontière maritime ne peut être établi d'une manière définitive, complète, full, que lorsque la CLPC aura déterminé que les deux États ont effectivement un titre maritime au-delà de 200 000 marins. En l'absence de titres qui se chevauchent, la délimitation du plateau continental au-delà de cette limite n'est pas nécessaire ou elle devient caduque si elle a été établie. De ce point de vue, il n'y a pas de désaccord entre les parties qui reconnaissent l'une et l'autre que les deux États ont bel et bien des droits au-delà de 200 000 marins et que leurs titres, leurs entitlements, se chevauchent. Par ailleurs, il n'est pas douteux que le point d'aboutissement de la délimitation entre les parties dépend des recommandations de la CLPC. Mais ceci ne signifie pas que les parties ne peuvent pas décider par accord l'orientation de la ligne de délimitation avant que la Commission se soit prononcée, ni que la Cour ou un tribunal arbitral doivent attendre les recommandations de la Commission pour établir une telle délimitation. Simplement, à la différence de ce qui se produit pour les autres espaces maritimes, la délimitation du plateau continental au-delà de 200 000 marins ne devient définitive et n'autorise les États à y exercer leurs droits souverains que lorsque la CLPC s'est prononcée sur leur titre. J'en veux pour preuve la pratique de nombreux États qui ont conclu des accords de délimitation fixant la limite de leur plateau continental étendu avant que la Commission ait adopté ses recommandations. Vous trouverez quelques exemples de cette pratique dans une note de bas de page dans le compte-rendu de l'audience. Et d'ailleurs, le Kenya lui-même n'a-t-il pas signé le 23 juin 2009, soit 2 mois après la conclusion du MOU, un accord avec la Tanzanie qui délimite la zone économique exclusive et le plateau continental entre les deux États, y inclut au-delà de 200 000 marins. L'article 2 de cet accord prévoit, il est sur l'écran, l'article 2 de cet accord prévoit que, je cite, « The parties agree that the boundary line extend eastwards to a point where it intersects the outermost limits of the continental shelf and such other outermost limits of national jurisdiction as may be determined by international law. » Cela confirme, si besoin était, que la délimitation n'est nullement dépendante de la délinéation, comme le soutenait le Kenya dans ses exceptions préliminaires et comme il a continué de le soutenir hier, mais m'a-t-il semblé avec un peu moins de conviction. Car, quoi qu'en ait dit Mathias Fortum, la jurisprudence est maintenant logiquement et fermement établie. Et contrairement à ce qu'a laissé entendre mon excellentissime ami, je ne pense pas que l'arrêt de votre haute juridiction du 17 mars 2016, qui va dans le même sens, constitue un revirement de jurisprudence. Vous avez simplement saisi la première occasion qui se présentait à vous pour préciser que la procédure devant, je cite, la procédure devant la Commission vise la délinéation de la limite extérieure du plateau continental et par conséquent la détermination de l'étendue des fonds marins qui relève des juridictions nationales. Elle est distincte de la délimitation du plateau continental régie par l'article 83 de la CNUDM, qui est effectuée par voie d'accord entre les États concernés ou par le recours aux procédures de règlement des différends. Fin de citation. Ceci dit, Monsieur le Président, ce qui n'est assurément pas dans le texte, c'est la précision que donne le Kenya, selon laquelle les parties se seraient engagées à procéder par la voie de négociation et non en ayant recours à une procédure contraignante, rather than recourse to any compulsory procedures. Ce n'est plus de l'interprétation, Monsieur le Président, c'est de l'invention, c'est de la broderie. Le texte ne dit rien de tel, le contexte ne conduit nullement à penser que ce soit le cas, et ceci n'a aucun rapport avec le but poursuivi par les représentants des deux États lorsqu'ils ont signé le MOU, but qui était d'obtenir que la CLPC établisse les limites extérieures de leur plateau continental au-delà de 200 000. Et ce n'est en effet qu'une fois cette délinéation acquise que la Somalie et le Kenya pourront conclure un accord délimitant complètement leurs frontières maritimes, delimiting the full extent of the maritime boundary. Et il n'est bien sûr pas davantage exact que cet engagement de procéder par voie d'accord à la délimitation complète de leurs frontières maritimes communes lorsque seront connues les recommandations de la CLPC, exclut qu'un tel accord puisse intervenir avant les recommandations de la CLPC. Après, after, ne se signifie pas exclusivement après, et rien n'empêche les parties de se mettre d'accord ex ante, sous réserve d'un éventuel ajustement ex post, au cas où il résulterait des recommandations de la Commission que leur accord empiète sur la zone internationale. Ici encore, le professeur Forteau se laisse aller au wishful thinking. L'accord de 2009, nous dit-il, précise par ailleurs que cette délimitation devrait faire l'objet d'un accord seulement après que la Commission des limites du plateau continental aura achevé l'examen des communications de chacun des deux États et après qu'elle aura formulé ses recommandations. Eh bien non, seulement est une pure invention qui n'est conforme ni à la lettre ni à l'esprit du texte. Le MOU n'exclut pas davantage qu'un accord partiel sur la partie du plateau continental dont l'indétermination ne dépend pas de la CLPC ne puisse pas être conclu, ni que des négociations en vue d'un accord global puissent être menées, quitte à réserver la détermination du point d'aboutissement de la frontière à l'après-recommandation de la CLPC. Pas plus que ceci n'empêche les parties de recourir à un règlement judiciaire ou arbitral si elles ne peuvent se mettre d'accord. Monsieur le Président, Mesdames et Messieurs de la Cour, non seulement l'interprétation du MOU défendue par le Kenya fait fi de la règle générale d'interprétation, mais encore elle conduit à un résultat manifestement absurde et déraisonnable. L'interprétation soutenue par le Kenya a plusieurs effets pratiques particulièrement pervers, mais qui au fond se ramènent à un seul. Il serait extraordinaire, pour ne pas dire extravagant, que deux États pauvres, pour lesquels l'exploitation de leurs ressources halieutiques et possiblement pétrolières, se soient entendus pour remettre aux calendes le règlement de leurs différends frontaliers, dont le MOU reconnaît l'existence tout en s'efforçant d'en hâter l'aboutissement. Au bénéfice de cette remarque générale, 3 points, je pense, méritent quelques brefs développements. Premièrement, s'il fallait en croire le Kenya, les deux États côtiers auraient conclu un accord établissant une méthode de règlement des différends inaccessible aux parties pendant de très nombreuses années. Car il ne faut pas se méprendre. Très malheureusement, les prédictions du professeur Akavan sur la perspective de voir la CLPC se prononcer sur la demande somalienne dans un futur proche sont démesurément optimistes. D'abord parce qu'il est hors de question que la Commission permette aux États de resquiller, to jam the queue. L'article 51, 4 ter de son règlement intérieur ne laisse aucun doute, les demandes prennent place dans l'ordre où elles sont reçues. Or, s'il est concevable, quoique improbable, que la plénière de la CLPC examine la demande kenyane l'an prochain, grâce au retrait de l'objection somalienne, celle de la Somalie se trouve au 74e rang et au rythme actuel d'environ 3 recommandations par an, sachant que 53 demandes ont la priorité sur celle de la Somalie, cela nous conduit vers l'année 2033. Je me permets, mesdames et messieurs les juges, de vous renvoyer à l'onglet 3 de votre dossier qui fait le point sur l'état d'avancement des travaux de la Commission au 8 juillet de cette année. Et l'optimisme de la droite avocate du Kenya est démenti par l'Assemblée générale des Nations unies qui, cette année encore, a pris note avec préoccupation du calendrier proposé par les travaux de la Commission consacrés aux demandes reçues. Est-il raisonnable d'interpréter le MOU comme excluant tout accord de délimitation, tant en deçà qu'au-delà de 200 000 jusqu'à 2003, privant ainsi ces deux pays qui aspirent à un développement économique rapide de la possibilité d'exploiter les ressources de l'importante zone en litige? Non, Monsieur le Président. Deuxièmement, si le Kenya avait raison et si le paragraphe 6 du mémorandum excluait d'avoir recours à un autre mode ou à d'autres modes de règlement, il s'ensuivrait que les termes équivalents, les articles 74 et 83 de la CNUDM ou de tout autre instrument prévoyant une délimitation par accord, devraient être interprétés comme excluant également tout recours à un juge ou un arbitre pour le règlement du différend de délimitation. Cette interprétation est tellement absurde qu'à ma connaissance, aucun État, ni même aucun auteur, c'est tout dire, ne l'a avancée jusqu'ici. Pourrait-elle être retenue par la Cour? Non, Monsieur le Président. Troisièmement, une autre raison, tout à fait décisive, qui traduit le caractère déraisonnable de l'interprétation kenyane, tient à ce qu'elle exclut la possibilité pour la Cour, ou tout autre organe de règlement obligatoire des différends, de trancher un litige relatif à une délimitation maritime tant que la CLPC ne s'est pas prononcée sur la délinéation du plateau continental. Voilà, mesdames et messieurs les juges, qui risquent de tarir sérieusement l'une des principales sources de litiges inscrits à votre rôle. Indépendamment de cette considération qui a son importance, je vois mal comment nos amis de l'autre côté de la barre concilient cette position avec la jurisprudence que j'ai citée il y a un instant et avec leur reconnaissance, et la reconnaissance expresse par le MOU, que la délinéation est sans préjudice de la délimitation. L'interprétation du Kenya introduit des contradictions irréconciliables dans l'instrument interprété. Peut-on admettre que le MOU, qui indique expressément qu'il est conclu sans préjudice de la question de la délimitation du plateau continental, est imposé aux États signataires de se plier à des procédures inutiles à seule fin de retarder ou d'entraver le règlement de leurs différends sur la délimitation? Non, Monsieur le Président. Et quatrièmement, hier, il m'a semblé que le Kenya en avait encore rajouté dans l'absurde en affirmant que la disposition contestée, je cite, « does not mean that the parties cannot negotiate prior to CLCS review. That would be absurd. The parties may negotiate prior to the CLCS recommendation, but they may finalize an agreement only after delineation of the outer limits of the shelf. » Nous n'avons pas, Monsieur le Président, la même conception de l'absurdité. Ce qui est absurde, c'est, je pense, que les parties auraient conclu un accord leur interdisant de conclure un accord. L'idée d'un pactum des negotiando sous réserve de ne pas conclure est totalement excentrique. Peut-on l'envisager? Non, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs de la Cour, l'interprétation que nos contradicteurs veulent vous convaincre de retenir est déraisonnable et aurait des conséquences absurdes. Si vous l'envisagez comme ayant un semblant de vraisemblance, il vous appartiendrait de faire appel aux moyens complémentaires d'interprétation pour déterminer la portée véritable du paragraphe 6 de MOU, mais en l'espèce, vous n'êtes aucunement réduit à une telle extrémité, comme je crois l'avoir montré, un raisonnement simple, fondé sur la règle générale d'interprétation de l'article 31, permet d'arriver à un résultat logique et parfaitement sensé. Néanmoins, comme l'article 32 l'envisage également, et comme la Cour l'a souvent admis, tant avant qu'après la conclusion de la Convention de Vienne, même lorsque le texte est clair et l'interprétation que l'on peut en donner objective, il est possible de rechercher dans les travaux préparatoires et dans les circonstances dans lesquelles le traité a été conclu une confirmation éventuelle de l'interprétation tirée du texte. C'est à quoi Maître Reichler va s'employer ex abundanti cautela dans un instant. Avant de vous demander, Monsieur le Président, de bien vouloir lui donner la parole, permettez-moi, je vous prie, une dernière remarque de portée plus vaste. Je dois dire qu'en règle générale, l'attitude de la partie kenyane dans cette affaire me laisse pour le moins perplexe. Voilà un pays en développement, légitimement pressé de se développer, qui a, je crois comprendre, de bonnes relations avec son voisin, lui aussi démuni et désireux de faire le meilleur usage de ses ressources naturelles. Et pourtant, le Kenya semble s'ingénier à faire traîner les choses et à empêcher que le différend sur la frontière commune qui oppose les deux pays et qui handicape lourdement leur développement soit réglé rapidement. Son interprétation du MOU en témoigne. Il en va de même des exceptions préliminaires artificielles et stériles qu'il a soulevées. J'avoue, Monsieur le Président, que quelque chose m'échappe. Merci, Mesdames et Messieurs les juges, pour votre très aimable attention et merci, Monsieur le Président, de bien vouloir appeler Maître Reichler à cette barre, maintenant ou après la pause.
Merci, Monsieur le Professeur. C'est le moment adéquat pour faire une pause de 15 minutes, après laquelle je donnerai la parole à Monsieur Reichler. La séance est suspendue. Veuillez vous asseoir. La parole est à Monsieur Paul Rackler.
Mr. President, distinguished members of the Court, it is, as always, an honor for me to appear before you. Today, I am privileged to speak on behalf of the Federal Republic of Somalia. Professor Pele has meticulously taken you through the text of the MOU. He has shown you, based on well-established principles of treaty interpretation, that the MOU is not an agreement on a means for settlement of the parties' maritime boundary dispute, nor does it prevent the parties from seeking to have that dispute resolved by this court. My role today will probably not come as a surprise to you. As is often my fate, I am tasked once again with analyzing the evidence that is before you. I make no complaint about that. I know my place. And especially in this case, I'm content with it, because the evidence of what the parties intended when they executed the MOU and how they understood it as reflected in their practice is an important part of the case. It can be of great assistance to the Court in determining the proper interpretation to be given to the MOU. We say the evidence fully supports Somalia's interpretation of the MOU, which is the one Professor Pele has just given you. We do not invoke the evidence in regard to the object and purpose of the MOU or the context in which it came about in opposition to a proper reading of the text. We invoke it to confirm our reading of the text. That evidence falls into two categories in relation to two different time periods. First, the evidence of the parties' intentions at the time the MOU was signed in April 2009. Second, the evidence of how they understood and interpreted the MOU subsequent to its execution from then until the case was commenced at the end of August 2014. I begin with the evidence of the parties' intentions at the time they signed the MOU. An important fact is that the MOU was neither conceived nor drafted by Kenya or Somalia. As Counsel for Kenya acknowledged yesterday, both the idea and the text came from Norway. The context helps explain what was intended. In early 2009, time was running out for coastal states to submit their outer continental shelf claims to the CLCS. Some states lacked the technical expertise to prepare these highly complex submissions. If they missed the deadline, their potential rights beyond 200 nautical miles might be lost forever. This was a particular concern in Africa. To address the situation, the General Assembly called upon UN member states, quote, to assist coastal African states in the preparation of submissions to the Commission regarding the outer limits of the continental shelf beyond 200 miles. Norway, to its credit, answered the call. It did so in several ways. First, it provided technical assistance to a number of coastal states in East and West Africa to help them prepare timely submissions to the CLCS. Second, because the Commission's rules of procedure permit states to block consideration of their neighbors' submissions merely by asserting the existence of a dispute, Norway facilitated and drafted agreements between and among neighboring states, committing them to refrain from objecting to CLCS review of each other's submissions. This was to allow the CLCS to issue recommendations on the outer limits of the continental shelf, with the understanding that these would be without prejudice to any boundary delimitation disputes. In West Africa, for example, Norway provided technical assistance to ECOWAS members in respect of their CLCS submissions, and also drafted and facilitated an agreement among them not to object to each other's submissions. As a consequence, even though Ghana and Cote d'Ivoire are now in litigation before a special chamber of ITLOS over their disputed maritime boundary, both have complied with the non-objection agreement drafted by Norway and refrained from objecting to each other's submissions to the CLCS. Norway played a similar role in East Africa. It signed on to provide technical assistance to Somalia, which needed its help. The deadline for the submission of its preliminary information to the CLCS was May 2009. Somalia at the time had no capacity to prepare its own submission. The transitional federal government was newly functioning. Its Herculean task was to create a viable state following from the collapse of governmental authority, 2 decades of chaos and civil war, and a militant insurgency which then controlled much of the country. Because of Norway's invaluable assistance, Somalia was able to submit its preliminary information in a timely manner. As it did in West Africa, Norway also sought to avoid objections from neighboring states that would preclude the CLCS from considering Somalia's submission. That was the reason Norway proposed the MOU. Like the non-objection agreement Norway brokered among the members of ECOWAS, Norway offered the MOU as a non-objection agreement between Somalia and Kenya so that the CLCS could review both states' submissions without objection from either one, notwithstanding their disputed maritime boundary. Norway had no interest in the boundary dispute itself. Its only concern was securing the non-objection of the parties so that their submissions could be properly reviewed by the CLCS. Kenya acknowledges that Norway, through its ambassadeur en mission spéciale, the late Hans Wilhelm Longva, drafted the MOU and presented it to the parties. Contemporaneous documentation shows that Ambassador Longva first presented a draft memorandum of understanding to the Somali Deputy Prime Minister on 10 March 2009, after previously discussing it with the chairperson of Kenya's task force on the delineation of Kenya's outer continental shelf. Both parties have appended to their written pleadings copies of the correspondence between Ambassador Longva and Kenya on the one hand, and between him and Somalia on the other, in regard to the MOU and its text. Significantly, there is not a single reference in any of the contemporaneous correspondence to settlement of the maritime boundary dispute or to the establishment of a method for resolving that dispute. Somalia proposed one change to Ambassador Longva's draft, and that was to the title. At Somalia's request, the words, quote, "to each other," were inserted so that the text read that Kenya and Somalia, quote, "grant to each other no objection in respect of submissions on the outer limits of the continental shelf beyond 200 nautical miles." As Professor Pele explained, both the original title and the final one reflect and are in keeping with the central object and purpose of the instrument, to secure the non-objection of each state to the CLCS submission of the other. The record shows that this is how the drafter of the MOU, Norway, and the 2 states that would be party to it, Somalia and Kenya, understood the object and purpose of the agreement. Ambassador Longva and Norway, in fact, took pains to distance themselves from and avoid involvement in settlement of the boundary dispute, and to separate that dispute as far as possible from the parties' submissions to the CLCS. At tab 5, And on your screens is an interview with Ambassador Longva, published in 2009. There, underneath his cheerful countenance, is his statement that following his return to the legal department of the Foreign Ministry in 2008, quote, "I am now responsible for a project relating to assistance to African coastal states in the establishment of the outer limits of the continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured." He says nothing about having any responsibility for delimitation of boundaries, dispute settlement, areas up to 200 miles, or the exclusion of recourse to international adjudication. At tab 6, and on your screens, are further remarks by Ambassador Longva given in November 2009, this time in an intervention to the Pan-African Conference on Maritime Boundary Delimitation in the continental shelf. They shed further light on his and Norway's intentions. Quote, "I want to stress from the outset that the establishment of the outer limits of the continental shelf is a different and separate issue from the delimitation of the continental shelf with opposite or adjacent coasts. The establishment of the outer limits of the continental shelf is without prejudice to. That is, it does not affect matters relating to the delimitation of the continental shelf between states. Consequently, it is not necessary to solve issues of maritime delimitation between neighboring states before embarking on the establishment of the outer limits of the continental shelf." Neither Ambassador Longva nor Norway set about to solve the issues of maritime delimitation between Kenya and Somalia. Their only concern was in preventing that dispute from interfering with CLCS review of the parties' continental shelf submissions. Norway provided its understanding of the object and purpose of the MOU between Kenya and Somalia in a note verbal to the Secretary General dated 17 August 2011. You will find this at tab 7 on page 4 and on your screen. Quote, "In the Memorandum of Understanding, MOU, the parties agree that at an appropriate time, each of them will make separate submissions to the Commission on the Limits of the Continental Shelf, CLCS, that may include areas under dispute between the two countries without prejudice to the delimitation of the maritime boundaries between them. In this MOU, the two coastal states grant their prior consent to the consideration by the CLCS of these submissions in the areas under dispute. Furthermore, it is stipulated that the submissions made before the CLCS and the recommendations approved by the CLCS thereon shall not prejudice the positions of the two coastal states with respect to the maritime dispute between them, and shall be without prejudice to future delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles. In its final paragraph, it is stipulated that, quoting from the MOU, this memorandum of understanding shall enter into force upon its signature. Tellingly, in describing the object and purpose of the MOU, Norway skipped right over the penultimate paragraph and said nothing about settlement of the parties' maritime boundary dispute, stating only that their consent not to object to each other's CLCS submissions was without prejudice to their respective positions on the boundary. Norway did not describe the MOU as an agreement on a specific method or timetable for settlement of the boundary dispute. Norway made no reference to settlement of that dispute or to how such a settlement might be achieved. On the subject of delimitation, Norway's note verbal said only this on page 3 and on your screens, quote, "The politically most sensitive issues involved may be the unresolved issues of maritime delimitation between Somalia and neighboring coastal states. Norway takes no position on these issues other than laying as a premise for its assistance that such issues of maritime delimitations with other states not be prejudiced." The court has no reason not to take Norway at its word. By its own description, in proffering and recommending execution of the MOU, Norway was not addressing or attempting to facilitate resolution of the parties' maritime boundary dispute. Rather, it sought only to ensure that the parties' submissions to the CLCS would be acted upon by that body. Norway's approach was thus to separate the parties' submissions to the CLCS from their maritime boundary dispute, so that the former could be addressed by the CLCS without implicating or prejudicing the latter. At the time the MOU was discussed and signed, no one, not Norway, not Somalia, and not Kenya, indicated that it considered the MOU to be concerned with settlement of the maritime boundary dispute. That intention is not present, not explicitly and not implicitly, in any of the contemporaneous records. Kenya's records confirm this. At tab 8 is the Kenyan Foreign Ministry's August 2009 internal memorandum regarding registration of the MOU with the UN. It describes the MOU as being, quote, in respect of submissions on the outer limits of the continental shelf beyond 200 miles. Nothing about dispute settlement is mentioned. Similarly, at tab 9, you will find a summary of Kenya's presentation to the CLCS in September 2009. There, the chairperson of the Task Force on Delimitation of Kenya's Outer Continental Shelf, the same person who was consulted about the MOU by Ambassador Longva prior to execution, is recorded as describing the MOU as, quote, a provisional arrangement of a practical nature whereby the parties undertake not to object to the examination of their respective submissions. Nothing about dispute settlement. The executive summary of Kenya's submission to the CLCS, an excerpt of which is at tab 10, also describes the MOU only as, quote, granting each other no objection in respect of submissions on the outer limits of the continental shelf. On the maritime boundary, the executive summary states merely that Kenya and Somalia will delimit their boundary, quote, pursuant to an agreement on the basis of international law. This is no more than a restatement of their mutual obligation under Articles 74.1 and 83.1 of UNCLOS. The MOU is mentioned in the same paragraph of Kenya's executive summary. Significantly, Kenya does not describe it as an instrument that addresses in any way the means to settle or reach agreement on the boundary. The contemporaneous evidence is thus conclusive. Kenya gave no indication that it regarded the MOU as imposing any obligations in regard to settlement of the boundary dispute. All of Kenya's statements from 2009 refer to the MOU solely as an agreement on non-objection to the parties' respective submissions to the CLCS, without prejudice to issues of maritime delimitation. There is nothing more than that. And the same is true for Somalia's contemporaneous statements. The transitional federal government was sworn in on 22 February 2009, just a few weeks before Ambassador Longva presented it with the draft MOU on 10 March. Senior Somali officials were informed of Norway's assistance with the submission to the CLCS at the same time that they received the draft MOU. For this reason, they assumed that the MOU and the submission were indivisibly connected to one another and that the MOU was necessary for the submission to be filed. In an email sent shortly after the 10 March meeting, the Deputy Prime Minister expressed his gratitude to Norway for, quote, doing all the work that we were supposed to do regarding the preparation of the preliminary information, and expressing his understanding that, quote, we must have the memorandum of understanding that Norway has prepared. This understanding was confirmed by the Minister of Planning and International Cooperation, who said that the Somali government believed it had to sign the MOU with Kenya in order to proceed with its submission to the CLCS. Thus, for Somalia as well as Kenya, The MOU was linked directly to the submission to the CLCS. It was not understood as an agreement on the means for settlement of the boundary dispute. In sum, the evidence surrounding the adoption of the MOU in 2009 fully supports Professor Pele's reading of the text. I turn then to the evidence of the parties' practice following execution of the MOU. The most important conduct during this period consists of the direct bilateral negotiations on the maritime boundary that the parties planned in 2013 and conducted in 2014. Kenya's own conduct directly contradicts its attempt to read into the MOU an agreement that the boundary would only be settled after the CLCS process was completed. At tab 11 and on your screens is a joint statement by the foreign ministers of Somalia and Kenya dated 31 May 2013. I apologize for the poor quality of the document, but I believe it's still legible. You can see that on page 2, the two ministers, quote, underlined the need to work on a framework of modalities for embarking on maritime delimitation. This was reflected in a newspaper article dated 10 June 2013, which reported that it was Kenya itself that had, quote, requested talks to demarcate maritime boundaries. Kenya has not disputed this. Notably, Kenya took this initiative to engage in negotiations to resolve the disputed maritime boundary well before the CLCS had issued any recommendations on delineation of the Outer Continental Shelf. Indeed, at the time, the CLCS had not even taken up consideration of either the Kenyan or the Somali submission. Just as notably, the joint statement also contradicts Kenya's assertion that the main purpose in proposing talks with Somalia was not delimitation of the maritime boundary, but persuading Somalia to withdraw the objection it had filed with the CLCS. The date of the joint statement is May 2013. Somalia did not make its objection to the CLCS until February 2014, 9 months later. What the joint statement therefore reflects is Kenya's understanding that there was no impediment in the MOU to resolving the maritime boundary dispute with Somalia before the CLCS had acted. Bilateral negotiations on the maritime boundary were commenced following a meeting between the two foreign ministers on 19 February 2014. Contemporary documentary evidence, including a letter from the Somali foreign minister to the Kenyan foreign minister, which you can find at tab 12 and on your screens, shows that at that meeting, Kenya again declared the, quote, willingness of the government of Kenya to engage the Somali government in regards to the existing dispute relating to the delimitation of the maritime boundary between the two countries. Kenya's foreign minister followed up the meeting with a note verbal to her Somali counterpart, inviting Somalia to send a delegation to Nairobi to commence negotiations on the maritime boundary. On this basis, the parties agreed to meet in late March 2014 to, quote, settle the dispute regarding the maritime boundary. There is no reference to the MOU or to any other alleged impediment to the settlement of the boundary dispute, or to the fact that the CLCS had not issued recommendations to either party. There's nothing to that effect in the Kenyan invitation, or in the Somali response, or in any other correspondence exchanged between the two states. Now, the significance of these exchanges is obvious. They contradict Kenya's current contentions that the MOU constitutes an agreement on a specific and exclusive means of settlement of the parties' maritime boundary dispute, which may take place, quoting them, only after the Commission has concluded its examination of the separate submissions made by each of the two coastal states and made its recommendations to the two coastal states, end of quote. Plainly, in 2013 and 2014, neither party regarded the absence of CLCS recommendations as an obstacle to the commencement of negotiations, to the resolution of the dispute by that means, or indeed to any other form of dispute settlement. Kenya knows that its willingness to negotiate a boundary agreement with Somalia in 2013 and 2014 reflects an understanding of the MAU that is completely incompatible with the one that it adopted after this case was commenced and which its counsel advocated yesterday. That is why they struggled so mightily to explain away those boundary negotiations. That unhappy task fell primarily to Ambassador Muchiri. Mr. President, you will recall being told that what took place were only, quote, technical level meetings. That is incorrect. The delegations to the second meeting in July 2014 were headed by the foreign ministers, and both were present during the talks. The court was also told that, quote, the primary purpose was not to hold substantive negotiations on the maritime boundary, but, quote, to discuss the breach of the MOU. Again, that is incorrect. In fact, it is completely belied by the evidence. At tab 13 and on your screens is the joint report of the meeting of 26 and 27 March 2014. It is referred to as the Kenya-Somalia Maritime Boundary Meeting. The report makes clear that the parties focused almost entirely on the maritime boundary. There were extensive discussions on that subject. For example, under the heading, Discussions on the Maritime Boundary, on page 2, 4 topics are listed as having been addressed. A, Kenya's departure from the equidistance methodology adopted by the Kenyan government in the 1972 Territorial Waters Act, as revised in 1977, and the 1989 Maritime Zones Act to the 2005 Presidential Proclamation. B, starting point for the determination of the maritime boundary. C, baseline and base points. D, potential maritime boundary line. In an effort to downplay these negotiations and their significance, Ambassador Muchiri and others referred to them as merely preliminary and only for purposes of, quote, confidence building. But that is not how the parties described them in their joint report, which contains a detailed record of their exchanges over 2 full days of meetings. The joint report refers in particular to a PowerPoint presentation Kenya made at the meeting. The Kenyan PowerPoint is at tab 14. As you will see when you review this document, this was a serious, substantive, and detailed presentation. It includes a map of the East African coastline, showing what Kenya considers to be a concavity giving rise to special circumstances, detailed models and calculations of the relevant coasts and relevant area, and maps depicting what Kenya considered the, quote, inequity it would suffer if the boundary were based on equidistance, as Somalia advocated at the meeting. The argument that you heard yesterday, that the meeting was not actually devoted to a detailed discussion of the maritime boundary, but was mainly concerned with Somalia's objection to the CLCS, is contradicted by the evidence before you. This is also reflected in the joint report's conclusion. Quote, the delegations, after considering several options and methods, including bisector, perpendicular, median, and parallel of latitude, could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted. Consequently, the two delegations resolved to refer the matter to the principals, that is, the foreign ministers, for further guidance. Somalia does not dispute that Kenya sought to place the MOU on the agenda for this meeting, or that Kenya wanted Somalia to withdraw its objection so that the CLCS would consider Kenya's submission. But that's not the critical issue here. We accept that the MOU says that neither state would object to the other's submission to the CLCS. That's not in dispute. The critical issue here is whether the MOU, beyond its no objection language, obligates the parties to a specific means of resolving their maritime boundary dispute. On this issue, Kenya's conduct in 2013 and 2014 is telling. At no time during that period, when bilateral negotiations on the maritime boundary were being proposed and conducted, did Kenya ever suggest that the MOU established a method, let alone an exclusive method, for resolution of the boundary dispute. To the contrary, Kenya's sole contention about the MOU was that it was a non-objection agreement with which Somalia had to comply. That was Kenya's only stated purpose in putting the MOU on the agenda for the bilateral meetings. Kenya seems to have only belatedly discovered, after this lawsuit was commenced, that the MOU bars any resolution of the maritime boundary dispute except by negotiations following action by the CLCS. Kenya admits that it never previously expressed this interpretation of the MOU. Professor Forto attempted to excuse this failure on the ground that Kenya had no prior occasion to make its view of the MOU known. We disagree. If this were truly Kenya's pre-litigation understanding of the MOU, it's reasonable to assume they would have brought it up in 2014, at which time, under Kenya's current view, the MOU would have prevented the parties from conducting any negotiations for the purpose of resolving the boundary dispute because there had been no action by the CLCS. The March 2014 negotiations were followed by a second round of talks 4 months later. Ambassador Muchiri told you, quote, "It is clear that Kenya initiated the meeting to discuss the MOU." That, too, is at odds with the record. Tab 15 and on your screens is a note verbal sent from Kenya to Somalia, inviting it to a second round of negotiations in Nairobi in July 2014. You will see that Kenya's invitation explicitly refers to, quote, "the negotiations between the government of the Republic of Kenya and the Federal Republic of Somalia on the delimitation of our overlapping maritime boundary." In the following paragraph, the note invites Somalia to the talks expressly to, quote, "discuss the issue on the delimitation of the two countries' overlapping maritime boundary." No reference is made to any discussion of the MOU or even to Somalia's objection to Kenya's submission to the CLCS. At tab 16 is the joint report of that July 2014 meeting. You were told yesterday that, quote, "maritime delimitation was discussed only in the most preliminary way." That is not what the report says. It establishes that the purpose of the meeting was reflected in its title, quote, "the Kenya-Somalia Maritime Boundary Meeting." The negotiating teams both made presentations on the issue of the maritime boundary, and, quote, "intense discussions between the two sides occurred in the presence of the two foreign ministers." Kenya now attempts to recharacterize this negotiating session. Its effort is defeated not only by the joint report, but also by its own internal report on the meeting, dated 8 August 2014. Somalia did not have this report at the time it filed its written statement in response to Kenya's preliminary objections, because Kenya chose not to disclose it when it filed those objections last year. The Kenyan report was only obtained by Somalia in June of this year with the assistance of the court after Somalia requested that Kenya produce all internal records pertaining to the negotiations that took place in March and July 2014. You can see this internal Kenyan document at tab 17. It's addressed to the Foreign Minister of Kenya and reports on, quote, the second boundary meeting, which it describes as a, quote, continuation of the March meeting. It does not mention the MOU at all. This is a significant omission in a Kenyan document intended to memorialize the key points discussed at the meeting. Instead, the document reports exclusively and extensively on the parties' exchange of views with regard to their maritime boundary dispute. As this report makes clear, what occurred was far more than a mere expression of so-called preliminary views. As described on the second page, Kenya's presentation addressed, quote, applicable maritime laws in Kenya, factors considered in arriving at the parallel of latitude, and a conclusion presenting the scenario, parallel of latitude, after application of the said factors. The document also notes that Kenya referred to case law and cited state practice. Such a detailed presentation is hardly a preliminary view. According to the report, Somalia made an equally detailed substantive argument in favor of its position that the boundary should be based on equidistance, also making explicit reference to case law. Tab 18 is Somalia's internal report of the meeting, which is consistent with Kenya's in regard to the matters discussed, including the extensive and detailed presentations made by each side in respect of its views on delimitation of the maritime boundary. Somalia's internal report of the July 2014 meeting, as you heard yesterday, includes remarks made by Kenya's foreign minister that are not reflected in Kenya's internal report, as seen on page 2, to the effect that, quote, if no agreement could be reached between both countries might resort to international arbitration. Kenya has disavowed that statement, including by means of a declaration by the foreign minister dated 5 May 2016, 21 months after this case was commenced. Somalia stands by the accuracy of its own contemporaneous pre-litigation report. In particular, Somalia underscores the two sentences immediately preceding the one that Kenya disputes. The foreign minister notably does not dispute the accuracy of those two sentences in her late-filed declaration prepared for purposes of these hearings. They are now on the screen. Quote, Minister Baile, that is Somalia's foreign minister, asked Minister Mohammed, Kenya's foreign minister, as to how long would both countries continue to have their delegations entangled in these heated discussions without any possible solution. Minister Mohammed of Kenya stated that although both delegations are far apart, she would like both teams to meet again and attempt one final time to find an amicable solution. One final time to find an amicable solution. As you heard from Somalia's agent, a third and final meeting was scheduled, but without explanation, the Kenyan delegation simply failed to show up. nor did it respond to Somalia's urgent inquiries by email and by letter correspondence asking Kenya when or whether the meeting would take place. At tab 19 and on your screens is a letter from Somalia's foreign minister to Kenya's, dated 26 August 2014. The letter reads on page 2, quote, "Further, as Your Excellency requested, at the conclusion of the meetings in regard to the pending dispute in Mogadishu on 25 and 26, I lost my place. At the conclusion of the meeting on 29 July, the Somali delegation agreed to hold one more round of meetings in regard to the pending dispute in Mogadishu on 25 and 26 August. The Somali delegation is deeply disappointed that the Kenyan delegation did not arrive on the agreed dates, preventing the meetings from taking place." No response to this letter was received. Somalia's decision to come to this court following unsuccessful substantive negotiations, which left the parties far apart and without prospect of settlement, together with Kenya's unexplained no-show at what was agreed would be the final meeting, cannot justly be described as precipitous. Much less can it be described as deceptive. Mr. President, what you heard yesterday simply cannot be squared with the evidence, which, as you have seen, consists of contemporaneous documentation whose authenticity and reliability are unchallenged, and includes materials produced and signed by both parties. That evidence makes it unmistakably clear that Kenya saw no contradiction in 2013 and 2014, before this case was filed, in proposing and engaging in negotiations to resolve the maritime boundary dispute long before the CLCS could issue its recommendations. At the same time, it was invoking the MOU to get Somalia to withdraw its objection to Kenya's submission. That is because there was no contradiction in Kenya's position then. It considered the MOU to be a non-objection agreement in regard to the parties' submissions to the CLCS. No more and no less. Kenya knows this evidence puts them in a difficult, if not desperate, situation in their attempt to invoke the MOU to escape the court's jurisdiction. Desperate circumstances often breed desperate measures, or at least desperate arguments. And that is the likely explanation for the argument elaborated for the first time yesterday. Previously, in its preliminary objections, Kenya argued that under the MOU, the method of settlement of the boundary dispute was, quote, to negotiate a full and final agreement on the maritime boundary delimitation after CLCS review of their respective submissions. They changed that yesterday. Their new argument, fabricated to fit the uncomfortable facts, is that the MOU did not prevent the parties from negotiating a resolution of their maritime boundary dispute prior to CLCS action. It only prevented them from reaching an agreement. Now, that would make the instrument, the MOU, a very unique document. Indeed, if not one of a kind. It would provide for negotiation of the maritime boundary dispute, but only so long as no agreement was reached. There are, of course, such things as agreements to agree. This would be the opposite, an agreement not to agree. It is plainly no such thing. Kenya's new argument simply makes no sense. It is certainly not how Kenya understood the MOU during the negotiations that took place in 2014. The objective of those meetings was to reach an agreement on the maritime boundary. That is clear from the joint reports as well as the parties' internal reports. The exchange between Foreign Minister Baile and Foreign Minister Muhammad demonstrates this, as does the subsequent letter from Minister Baile to Minister Muhammad. The ministers agreed at the end of the July meetings to meet again and attempt one final time to find an amicable solution. They did not say, quote, but unfortunately, we cannot achieve a solution because the MOU doesn't allow us to. Kenya's conduct, even after the present case was commenced, contradicts the new interpretation of the MOU. On 24 October 2014, 2 months after Somalia's application was filed, Kenya sent a note verbal to the UN Secretary General. It is at tab 20 and on your screens. In this document on page 2, Kenya states, quote, Kenya remains committed and continues to pursue more legitimate avenues to have the delimitation of the maritime boundary amicably resolved, most preferably through a bilateral agreement with the Somali Federal Republic, and in this regard wishes to inform that, notwithstanding the aforementioned actions by Somalis, that is, the objection to Kenya's CLCS submission, bilateral diplomatic negotiations at the highest levels possible are ongoing with a view to resolving the matter expeditiously and with a view to continuing peaceful cooperation, security, and stability in the region. If another death blow to Kenya's new interpretation of the MOU is required, this note verbal deals it. It was sent at a time when Somalia's objection was still in effect, and after the CLCS determined that it could not even create a subcommission to review Kenya's claims. In other words, CLC action was not even possible. Yet, Kenya represented to the Secretary General that it would continue negotiations at the highest levels to achieve a resolution of the maritime boundary dispute expeditiously, not 10 or 20 years from now, not after the CLCS has acted, but expeditiously. Obviously, Kenya did not then consider the MOU a bar either to negotiations or to an expeditious agreement. Mr. President, members of the Court, I can state my conclusions very succinctly. The contemporaneous evidence, consisting of statements and conduct of the parties and of Norway as drafter and broker of the MOU, shows clearly and unambiguously that neither Kenya nor Somalia nor Norway ever considered the MOU to be a binding agreement on a specific means of settling the parties' maritime boundary dispute. To the contrary, all of the principals saw it for what it was, an attempt to remove potential obstacles to CLCS consideration of their outer continental shelf submissions by obligating them not to raise objections to each other's submissions and nothing else. Insofar as references were made to the maritime boundary dispute, these were understood to be for the purpose of separating that dispute from the claims submitted to the CLCS and of preserving and avoiding prejudice to the parties' respective positions on the boundary. The purpose of the penultimate paragraph of the MOU was not to settle the boundary dispute or prescribe a means for doing so, but to separate and insulate it from the effects of the parties' understanding on non-objection to their respective submissions to the CLCS. Mr. President, the interpretation given by the parties to the MOU, as reflected in their consistent conduct, does not support Kenya's attempt to use the MOU to block Somalia's recourse to the court in this case. And as Professor Pele has already shown you, neither does the MOU's text. Mr. President, members of the court, I thank you for your kind courtesy and patient attention, and I ask that you call Professor Sands to the podium.
Merci. Je donne la parole au professeur Philippe Sands.
Monsieur le Président, members of the Court, it's an honour for me to appear before you in these proceedings on behalf of the Federal Republic of Somalia. You've heard from Professor Pillay on the proper interpretation of the MOU, a slender document on which Somalia places much weight. And you've also heard from Mr. Reichler on the manner in which the MOU was negotiated and understood by the parties, a text and context that both indicate that the MOU is not and was never intended or understood to be an agreement concerned with the delimitation of the parties' maritime boundary. I shall address Kenya's claim that the MOU falls within the scope of the first reservation to its optional clause declaration. By that argument, Kenya hopes to persuade the Court that it has no jurisdiction to examine Somalia's application under Article 36(2) of the Statute of the Court, and I'll seek to explain why Kenya's argument is without foundation in fact and in law. Before addressing that argument, however, an initial observation may be appropriate. In its written preliminary objections, Kenya invested considerable time and effort in seeking to persuade the Court not to render the impartial and legally authoritative binding ruling that would bring to an end the protracted maritime boundary dispute that so disrupts relations between the parties. Kenya seems hostile to an authoritative judicial determination by this Court, although not necessarily to an Annex 7 arbitration, depending on how one understands Professor Boyle. The apparent hostility towards this Court was made rather clear again yesterday, and it's perhaps a reflection of Kenya's growing recognition that its claim to a maritime boundary based on a line of parallel is without merit, a claim that it has surely been advised would most likely fail before this Court. Equally without merit is Kenya's unhappy reliance in its pleadings on the doctrine of unclean hands, an argument that might invite a wistful response. Is Kenya's particular invocation of good faith and mutual consent simply a means of prolonging its own unilateral conduct in the disputed maritime area? As Somalia has explained in its written statement, Kenya's reliance on its optional clause reservation, like its claim to a parallel maritime boundary, and we would say its clean hands argument, faces considerable legal and factual obstacles. And chapters 2 to 4 of our written statement contain a detailed exposition of the defects in Kenya's case. Anywhere but the ICJ in The Hague, Kenya in effect told you yesterday, and nowhere else either, unless subject to a delay of the kind that would entrench the status quo, continue the uncertainty, and prolong the instability. To accede to Kenya's request would extinguish the potential role of this Court, the principal judicial organ of the United Nations, not only in this case, but in many others. Let's start with Kenya's optional clause declaration, made under Article 36(2), an integral part of the Court's jurisdictional framework. Somalia and Kenya have been parties to the optional clause system for more than half a century, as both states made declarations under Article 36(2) shortly after they attained independence from colonial rule in the 1960s, Somalia on the 11th of April 1963, Kenya on the 19th of April 1965. Their long-standing participation in the optional clause system reflects a shared commitment to the object and purpose of the statute. That purpose, as the court observed in the Legrand case, is, and I quote, to enable the court to fulfill the functions provided for therein, and in particular, the basic function of judicial settlement of international disputes by binding decisions in accordance with Article 59 of the statute, end of quote. This aim underpins Somalia's application. It is reflected, too, in the United Nations General Assembly's aspirations that, and I quote, legal disputes should, as a general rule, be referred by the parties to the International Court of Justice, end of quote. As this court explained in the Nottebohm case, compulsory jurisdiction under 36(2), I quote, results from a previous agreement which makes it possible to seize the court of a dispute without a special agreement, end of quote. That previous agreement arises from the existence of convergent optional clause declarations by the states concerned. And in this case, contrary to what we heard yesterday from Counsel for Kenya, the declarations of Somalia and Kenya are convergent, and they do allow the court to exercise jurisdiction. As the court explained in the Nicaragua case, optional clause declarations, and I quote, establish a series of bilateral engagements with other states accepting the same obligation of compulsory jurisdiction, end of quote. At its heart, therefore, the optional clause system involves a series of binding mutual obligations grounded in reciprocity. Those bilateral relationships reflect a shared recognition of this court's unique and significant role in the peaceful resolution of disputes between states. The bilateral character of the obligations established under Article 36(2) is significant because it indicates that only a deliberate, clear, and unambiguous exclusion of the court's jurisdiction can operate to oust the right of one state to bring an application before the court against the other. In the present case, it is readily apparent that no such exclusion applies. Let's look at the first reservation to Kenya's optional clause declaration. It covers disputes in regard to which the parties to the dispute have agreed or shall agree to have recourse to some other method or methods of settlement. As the parties have explained in their written submissions, no fewer than 34 other states have entered materially identical reservations in their optional clause declarations. To accede to Kenya's interpretation would therefore be to undermine the potential role of this court in respect of these declarations, a role for the court that is more important today than ever before. It would also be a novel and unprecedented step in the court's jurisprudence. As the then president of the court observed in a speech in 2010, and I quote, 40 states have limited their optional clause declarations by stipulating that any other mechanisms of dispute settlement, as agreed between the parties, will prevail over the general jurisdiction of the court. In the few cases where this condition has been at issue, the court found that it did not exclude recourse to ICJ adjudication. It's very difficult to see how this case could be any different, how the MOU could reasonably be interpreted as an agreement to have recourse to another method of settlement, or indeed to exclude the right of recourse to this court. Kenya's entire argument rests on the interpretation of a single sentence, an aspirational line that it says excludes judicial settlement of the dispute concerning the maritime boundary. That single sentence is located in a document that is, on its face, concerned exclusively with the delineation of the outer limit of the continental shelf. Without textual or contextual support, Kenya seeks to elevate that line into a binding agreement that requires the entire disputed maritime boundary, including the territorial sea, the EEZ, and the inner continental shelf, of which the MOU makes no mention at all, to be delimited only by negotiation between the two states. On Kenya's approach, that one line excludes any recourse to this court on any matter of maritime delimitation. And as Professor Pele has explained, the single sentence mirrors the language of Articles 74 and 83(1) of UNCLOS. This is boilerplate language. It goes no further than the general provisions of international law that have bound the parties since they ratified UNCLOS. The line does not develop, supplement, modify, or magnify those general obligations. It says nothing about the right of recourse to the court, about the optional clause, or about other possible methods of judicial or arbitral determination. It contains no exclusionary language, not expressly and not impliedly, and it offers no details about the form, duration, and scope of any supposedly mandatory negotiations. It simply cannot bear the great weight that Kenya seeks to place upon it. In assessing Kenya's far-fetched claim, we would invite you to bear in mind a number of points. First, Kenya's optional clause declaration does not contain any express exclusion in respect of maritime delimitation disputes in general or the maritime boundary dispute with Somalia in particular. Had Kenya wished to exclude such disputes from the scope of its optional clause declaration under Article 36, paragraph 2, it could very easily have done so at any time during the 5 decades since it made its declaration in 1965, as many other states have done. Indeed, Kenya's declaration expressly reserves the right at any time to add to, amend, or withdraw any of the foregoing reservations. It did not do so, not before 2009, not in 2009, and not in 2014. Second, if the MOU had been intended to exclude judicial delimitation of the contested maritime boundary and to enshrine negotiations as the exclusive method of resolving the dispute, then one would expect the document to contain express and unambiguous language to this effect, given the far-reaching consequences such an interpretation would entail for both parties. It did not do so. There is no hint in the language of the MOU that the document was intended to exclude or prescribe any particular method of resolving the boundary dispute. On the contrary, the title and the text of the MOU make it clear that the document was concerned solely with the delineation of the outer continental shelf. The MOU was not intended to and does not concern matters of delimitation or dispute resolution relating to delimitation. Third, as Mr. Reichler pointed out, there is no evidence in the drafting history leading up to the signing of the MOU that either party believed itself to be agreeing to exclude recourse to judicial determination of the disputed maritime boundary. Kenya has offered no contemporaneous evidence, nothing, to suggest that the parties considered that they were renouncing recourse to the court or any other tribunal in favor of perpetual negotiations. Fourth, Kenya's attempt to characterize the MOU as an instrument that established a mandatory process for delimiting the parties' maritime boundary is undermined, fatally we say, by the fact that the document contained no reference to the maritime boundary within 200 miles. It did not contain any reference to the EEZ or the territorial sea, not expressly, not implicitly. Had the MOU also been intended to exclude the court's jurisdiction to determine the boundaries of the territorial sea and the EEZ, and had it intended to make bilateral negotiations the only possible means of delimiting those boundaries, then the text of the document, we say, would surely have referred to these zones expressly. yet it says nothing at all about them. Indeed, the MOU itself defines the maritime area in dispute strictly in terms of the continental shelf. And as Professor Pele explained with great clarity, this is consistent with the singular purpose of the MOU, a document concerned only with the delineation procedures for the outer continental shelf. Fifth, the court will have noted that during protracted negotiations with Somalia in 2014, on no occasion did Kenya ever assert that the MOU fell within the scope of the first reservation to its optional clause declaration. Had it considered this to be the case, surely Kenya would have made that assertion. It did not do so. Sixth, and in relation to this last point, there is no evidence to indicate that before it filed its preliminary objections on the 7th of October 2015, that Kenya ever expressed the view, internally or externally, that the MOU was an agreement to settle the maritime boundary dispute by negotiation only, to the exclusion of all other means of peaceful settlement of disputes. It was only after Somalia seized the court that Kenya sought to characterize the document in this new and different light. Kenya's radical new characterization of the MOU is an invention of the fertile legal minds whose task was to create an exception after they were retained to assist in this case. Seventh, if quod non, Kenya is right that the language of the MOU is an agreement to have recourse to some other method or methods of settlement, then it would appear to follow that the materially identical language of Articles 74 and 83 of UNCLOS would have the same effect. And this would have truly radical consequences that were surely not anticipated by the drafters of or the parties to UNCLOS. On Kenya's approach, Articles 74 and 83 have the effect of automatically depriving the court of jurisdiction under Article 36, paragraph 2 of the statute, in respect of any delimitation dispute concerning the EEZ or continental shelf of a state that is a party to UNCLOS and whose optional clause declaration contains a similarly worded reservation to Kenya's reservation. That would be a truly startling outcome, to put it mildly. Given that at least 33 other states that are parties to UNCLOS and the optional clause have entered the same or a similar reservation as Kenya, the consequence of this court acceding to Kenya's approach would seem to be to deprive the court of its optional clause jurisdiction over maritime delimitation disputes involving almost half of the 72 states that have accepted jurisdiction under Article 36, paragraph 2. Mr. President, members of the court, that is the conclusion that Kenya is inviting you to impose upon yourself. It cannot be right that so many states would have unwittingly deprived the court of its jurisdiction in this way. In short, our submission is that the MOU does not trigger Kenya's reservation to its optional clause declaration. Kenya's arguments to the contrary are unsustainable, as it surely knows, and it would have dire implications for the future role of the court, not least, but not only, in relation to the settlement of maritime boundary disputes. However, even assuming arguendo that the MOU was a binding agreement that was capable of falling within the scope of Kenya's optional clause reservation, this would not deprive the court of jurisdiction to hear Somalia's application. The reason for this is simple. If the MOU created any obligation regarding a negotiated settlement of the disputed maritime boundary, it was at most a limited obligation of endeavour, not of end. The MOU was not a pactum de contrahendo, an agreement to agree. It was at most a pactum de negociando, an agreement to attempt to agree. And as Mr. Reichler has explained, this is exactly what the parties did over a period of several months in 2014, but to no avail. After high-level, forceful, but ultimately futile negotiations between the parties reached an intractable deadlock. The parties themselves recognized this, and in a last-ditch effort to reach an amicable solution, did, as you have heard, agree to have one final meeting, but it never took place because Kenya, without notice, simply failed to show up and refused thereafter, as you have heard, to respond to Somalia's request for an explanation. Accordingly, having exhausted any obligation to negotiate under the MOU, the document could not trigger Kenya's reservation. In the Mavromatis Palestine concessions case, the Permanent Court of International Justice observed, negotiations do not, of necessity, always presuppose a more or less lengthy series of notes and dispatches. It may suffice that a discussion should have been commenced, and this discussion may have been very short. This will be the case if a deadlock is reached, or if finally a point is reached at which one of the parties definitively declares himself unable or refuses to give way. And there can therefore be no doubt the dispute cannot be settled by diplomatic negotiation. And as the court explained in Nicaragua versus Honduras, and I quote, "It is sufficient if, at the date on which a new procedure is commenced, the initial procedure has come to a standstill in such circumstances that there appears to be no prospect of its being continued or resumed," end of quote. While the context in that case was different, those words are an apt description of the situation in the present case. This court has defined negotiation as being, and I quote, "a genuine attempt by one of the disputing parties to engage in discussions with the other disputing party with a view to resolving the dispute," end of quote. It's very hard to see how it can be said that negotiations did not take place, even if Kenya now seeks to attach rather different labels to what happened. The reality, too, is that both sides knew they were involved in negotiations, and they knew they were going nowhere and would lead nowhere, not in a real sense, with no prospect of moving beyond the standstill. To recap, negotiations between the parties began in March 2014. The first round took place in Nairobi. The title of the agenda referred to the Kenya-Somalia maritime boundary meeting. At that meeting, the parties' delegations articulated their respective positions concerning delimitation of the maritime boundary. The Kenyan delegation presented a detailed multi-slide PowerPoint presentation setting out Kenya's argument in support of its claim to a boundary along a parallel of latitude. Amongst other things, the two negotiating teams discussed the reasons for Kenya's departure in 2005, a decade earlier, from its previous recognition of an equidistance boundary. They discussed the starting point for the determination of the maritime boundary, the location of the baseline and base points, and the path of the possible maritime boundary line. Despite those detailed exchanges, the joint report recorded that the delegations could not reach a consensus on the potential maritime boundary line acceptable to both countries to be adopted. Following consultations with their respective principals, a further round of high-level negotiations took place in Nairobi in July 2014. This was at a very senior level. The foreign ministers of Kenya and Somalia attended those talks. In Kenya's words, they took place at the highest levels possible. Yet Kenya maintained its insistence that the boundary line must follow a parallel of latitude. Somalia continued to emphasize that in accordance with UNCLOS and established principles of general international law, an equidistance approach was the appropriate methodology for the delimitation. Despite intense discussions, the parties did not make any progress at all, and they came no closer to reaching an agreed settlement of any part of the boundary or even a common view as to the appropriate method of delimitation. The state of deadlock was reflected in a comment by the Somali foreign minister, who asked in frustration at the end of the talks, and I quote, "How long would both countries continue to have their delegations entangled in these heated discussions without any possible solution?" I'll just offer an aside. Our friends from Kenya remarked on the curiosity of our distinguished agent drafting that report on the July negotiations in English rather than in Somali. Annex 24 to Somalia's memorial is another report in English submitted by the same agent on the 1st of April 2014. And that illustrates that English is, in fact, the distinguished agent's working language, as she has lived and worked abroad for many years, and that she frequently submitted her reports in English. Notwithstanding the deadlock, a third round of negotiations was scheduled to take place in Mogadishu, as you now know, a final opportunity to explore possible common ground. Contrary to what you heard yesterday, those negotiations were not seen merely as one of many potentially future rounds of negotiations, but were described by both parties as an attempt, one final time, to reach a negotiated solution. As the court has seen in our written pleadings, however, the Kenyan delegation chose not to show up. No explanation or advance notification was provided. They just didn't arrive, and they never gave any prior notice or any reason. The first two rounds of talks having failed to make any progress, and the third having been thwarted by a Kenyan no-show, it was clear to Somalia that an impasse had been reached. The position at the date of Somalia's application to the court is therefore reminiscent of the situation that pertained in the rights of passage case, where the court observed that, and I quote, "While the diplomatic exchanges which took place between the two governments disclosed the existence of a dispute between them on the principal legal issue which is now before the court, an examination of the correspondence shows that the negotiations had reached a deadlock." End of quote. If Kenya's approach is correct, then the parties will be obliged to engage in an indefinite process of negotiation, notwithstanding that previous attempts had ended in intractable deadlock. The parties must continue to negotiate, and only to negotiate, no matter how great the distance between them, between their respective positions, no matter what unilateral activities Kenya is undertaking in the disputed area, and no matter how entrenched or unreasonable Kenya's stance may be in the negotiations. They must continue to negotiate, Kenya says, even after one of the parties fails to attend a final meeting at which the negotiations are to conclude. Kenya's position, we say, is a recipe for deadlock, for a guarantee of indefinite conflict. Mr. President, it seems that Kenya is now aware of the weakness of its primary argument, and that is why it has chosen to advance another argument, both subsidiary and lackluster, which is said to be based on Part 15 of UNCLOS. That argument was limited to a single paragraph in its preliminary objections, one in which Kenya contended, without explanation or elaboration, that, and I quote, "the UNCLOS Part 15 methods of settlement would also trigger Kenya's reservation and exclude the court's jurisdiction," end of quote. Now, you heard Kenya's counsel yesterday. Professors Boyle and Lowe sought to add to that argument, or non-argument. They certainly made it longer, indeed, so much longer that one is bound to wonder whether it reflects a recognition of an understanding of the weakness of their main argument. But that length did not make it any more plausible. And let me be blunt, the argument is hopeless. For Part 15 of UNCLOS does not and cannot affect the binding agreement established by Kenya and Somalia's matching, convergent, overlapping, optional clause declarations. If Kenya is right, the court's jurisdiction would be extinguished with respect to maritime disputes between the states that are parties to UNCLOS with a similar optional clause reservation to Kenya. The agreement that arises by virtue of the matching declarations made under Article 36, paragraph 2 of the statute, and they are matching, and they do converge, and they do overlap, takes priority over the dispute resolution procedures contained in Articles 287 of UNCLOS. Article 282 of UNCLOS makes the relationship between these provisions clear, a point we emphasized in our written application and to which Kenya has offered no credible response in its written pleadings or yesterday. Article 282 provides as follows. If the states parties which are parties to a dispute concerning the interpretation or application of this convention have agreed through a general, regional, or bilateral agreement or otherwise that such dispute shall, at the request of any party to the dispute, be submitted to a procedure that entails a binding decision, that procedure shall apply in lieu of the procedures provided for in this part, unless the parties to the dispute otherwise agree. Many leading commentators have repeatedly confirmed that Article 282 has the effect of ensuring that the jurisdiction established by convergent optional clause declarations takes precedence over the dispute settlement procedures contained in Part 15 of UNCLOS. For example, in his recent textbook on the international law of the sea, Professor Tanaka confirmed there appears to be little doubt that the optional clause under Article 36(2) of the statute of the ICJ is a procedure that entails a binding decision set out in Article 282. It would seem to follow that between two states which have accepted the optional clause, the jurisdiction of the ICJ prevails over procedures under Part 15 of UNCLOS by virtue of Article 282. Professor Treves too concurs with that analysis. As he put it, the acceptance by all parties to a dispute of the court's compulsory jurisdiction under Article 36, paragraph 2 of the court statute can be considered the agreement mentioned in Article 282. And he continues, the consensual aspect, which seems to be the fundamental requirement of Article 36, paragraph 2, undoubtedly exists, so that it is reasonable to conclude that the parties have agreed otherwise. Accordingly, Professor Treves states that whenever both parties to a dispute have accepted the optional clause, ITLOS should declare that it has no jurisdiction over the dispute as a consequence of the operation of Article 282. And Judge P.C. Rao confirms this understanding of the relationship between Part 15 of UNCLOS and Article 36(2) of the statute of the court. He writes, the agreement referred to in Article 282 UN Convention on the Law of the Sea may be recorded otherwise, for example, through separate declarations, such as declarations made under Article 36(2) ICJ statute. These authorities are fully consistent with the UNCLOS commentary which we cited in our written statement. The authoritative commentary quoted at paragraph 3.83 of our statement explains, Article 282 mentions that an agreement to submit a dispute to a specified procedure may be reached otherwise. This reference was meant to include, in particular, the acceptances of the jurisdiction by the International Court of Justice by declarations made under Article 36, paragraph 2 of the statute of that court. And this has also been the view of Professor Boyle, at least until yesterday. In his article dealing with Article 282, which was published in 1999, he wrote, thus, two states which have made declarations in similar terms under Article 36(2) of the ICJ statute will remain subject to the compulsory jurisdiction of the ICJ even in LOS convention cases. This view seems to have been abandoned yesterday. Professor Boyle began his new approach by accepting correctly that if two states entered identical optional clause declarations, then Article 282 would ensure that these optional clause declarations prevail over any alternative UNCLOS Part 15 procedure. Professor Boyle's hypothetical example rightly recognized that the parties to UNCLOS intended the court's jurisdiction under the optional clause to trump the other methods of dispute resolution set out in Part 15. Professor Boyle proceeded to attempt to distinguish the present case from a case where there are identical optional clause declarations. And that is where, with the greatest respect, we say he fell into error. He says that Kenya's reservation means there are no matching optional clause declarations between the parties, and therefore the conditions stated in Article 282 are not met. It is not clear to us whether in making this argument, Professor Boyle now suggests that jurisdiction will only exist where optional clause declarations are identically worded. If so, that is very obviously wrong, as this court has long ruled. To bring the case within Kenya's reservation, Kenya has to establish that by signing UNCLOS, the two parties agreed to submit their maritime boundary dispute to the settlement procedures contained in Part 15. However, while Part 15 of UNCLOS does establish dispute resolution procedures, as you know, it contains a specific exception in Article 282, where states have agreed that a dispute shall be submitted to some other procedure that entails a binding decision. And as we've seen, the exception in Part 15 is widely accepted to include situations where both case states have entered optional clause declarations. Accordingly, in order to persuade you, this court, that you lack jurisdiction under the optional clause, Kenya is now forced to rely on a treaty, UNCLOS itself, that contains a deliberate renvoi back to the optional clause and which deliberately defers to jurisdiction under the optional clause. Kenya now argues that UNCLOS engages its reservation while simultaneously relying on its reservation to exclude a provision of UNCLOS. One might call this a sort of theory of double renvoi. We might also call it double bootstraps, a sort of game of endless ping-pong back and forth between the two instruments. But the essential idea is that each instrument extinguishes the other. The argument certainly has a quality that is dizzying, but perhaps not in the way it was intended. In the present case, there can be no doubt that both conditions established by Article 282 of UNCLOS are met. The first condition, that the parties have agreed to submit their dispute to a procedure that entails a binding settlement, is met by virtue of the converging optional clause declarations of Kenya and Somalia. The second condition, that the body selected by the parties must have power to interpret and apply UNCLOS in order to resolve the dispute, is also undoubtedly satisfied. This court has jurisdiction to interpret and apply UNCLOS. Indeed, that is a function it has found no difficulty in fulfilling in many recent cases. Somalia and Kenya have both ratified UNCLOS and are therefore bound by its provisions vis-à-vis one another. Somalia's application expressly states that the law applicable to this dispute is the 1982 United Nations Convention on the Law of the Sea, and the application explicitly requests the court to determine the disputed maritime boundary by applying Articles 15, 74, and 83 of UNCLOS. So Somalia's application falls squarely within Article 282. Lastly, I turn to Kenya's unhappy attempt to invoke as an admissibility argument the doctrine of unclean hands against Somalia. In its preliminary objections, Kenya objected loudly to the steps that Somalia had previously taken in relation to Kenya's CLCS submission and complained that Somalia had breached the MOU by seeking to resolve the issue of delimitation before the CLCS has delineated the outer continental shelf. Kenya claimed that this rendered Somalia's application inadmissible. Kenya advanced this argument half-heartedly in its written pleadings, just 4 terse paragraphs at the end of its written submission. Yesterday, it received no more than an oblique passing reference, if it can be called even that, in the oral submissions. We understand why Kenya has gone light on this argument and said nothing about it yesterday. It is manifestly wrong. First, it's based on the same erroneous conflation of delimitation and delineation that permeates the entirety of Kenya's preliminary objections. Second, Somalia is not seeking to invoke the MOU as the basis for the court's jurisdiction. Even if Somalia were in the breach of the MOU, which it is not, this would not preclude Somalia from invoking its entirely separate rights under Article 36(2) of the statute. Third, there is no precedent for applying the unclean hands doctrine in proceedings between states. On every occasion when the court has been invited to apply the doctrine, it has declined to do so. As noted in the latest edition of Brownlee's Principles of Public International Law, a text, I would add, that admirably reflects the spirit and approach of the distinguished author of earlier editions, the International Court has never applied the doctrine, even in cases where it might have done so. And fourth, regardless of whether it could ever be applied in the context of an interstate case, the court's case law confirms that accusations of bad faith of the type levelled against Somalia cannot bar the admissibility of an application. In any event, Kenya's allegations are unfounded in fact. Somalia's objection to Kenya's CLCS submission was a reasonable measure in the circumstance. It was taken as a last resort in response to Kenya's persistent and unjustified assertion of a parallel boundary claim and its persistent and unjustified unilateral activities in the disputed area. These jeopardized and hampered the possibility of reaching a final agreement, contrary to Articles 74 and 83 of UNCLOS. Somalia acted reasonably in the face of Kenya's unilateral conduct. It came to this court. There is no more reasonable act one could imagine. As to Somalia's objection to the CLCS, it was withdrawn, and Kenya's submission is now before the CLCS without any real delay. Kenya has not been prejudiced in any way. The door to this court, we say, cannot be shut. Monsieur le Président, members of the court, we hope you will see Kenya's preliminary objections for what they truly are: an effort to prolong an unjust and unprincipled status quo. To foreclose judicial determination of this dispute, Kenya calls for endless, pointless negotiations. It relies on an MOU that has nothing to do with delimitation. It attempts to bolster those submissions with 2 subsidiary arguments that are manifestly hopeless. There is, of course, here a certain irony. It is Kenya that invokes endless negotiations and allegations of bad faith to exclude a realistic possibility of a resolution to this dispute. And in so doing, it has to be said, it seems to be willing to sacrifice you, the court, depriving you of a meaningful role in resolving this maritime boundary dispute and, by consequence, many other maritime boundary disputes and possibly many other disputes. The outcome Kenya seeks is not justified in law, and in policy it would have nefarious practical consequence. This court offers the hope of an end to uncertainty, and with it the tantalizing prospect of less instability in a region that craves progress. This court has jurisdiction, and we trust you will exercise it. With this, I close Somalia's first round, and on behalf of my distinguished agents, thank you very much, sirs, for your kind attention.
Merci, Monsieur le Professeur. Ceci met fin à l'audience d'aujourd'hui et clôt le premier tour des plaidoiries. La Cour se réunira à nouveau demain, mercredi 21, à 16h30, pour entendre le Kenya en son second tour de plaidoirie. À l'issue de l'audience, le Kenya présentera ses conclusions finales. La Somalie prendra pour sa part la parole vendredi 23 à 10h pour son second tour de plaidoirie. À la fin de l'audience, elle présentera à son tour ses conclusions finales. Je rappellerai que conformément au paragraphe 1 de l'article 60 du règlement de la Cour, les exposés oraux devront être aussi succincts que possible. J'ajouterai que le second tour de plaidoirie a pour objet de permettre à chacune des parties de répondre aux arguments avancés oralement par l'autre partie ou aux questions posées par les juges. Le second tour ne doit donc pas constituer une répétition des présentations déjà faites par les parties, lesquelles ne sont au demeurant pas tenues d'utiliser l'intégralité du temps de parole qui leur est alloué. Je vous remercie. L'audience est levée.